Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Welcome to today's Savant Live webinar. Thank you for joining us. My name is Alaina Davalos, and I'm a wealth transfer advisor in our Atlanta office, but today I'm joining you from our Huntsville office, so that's fun. Today we'll be discussing estate planning beyond the basics. We have done an Estate Planning 101 webinar before, and we wanted to take this to the next level. If you missed that one, that's okay. We will recap a little bit to get you up to speed. And joining me today is Dominick Parillo. Welcome, Dom.
Hey, Alaina. Glad to be here. I'm really excited about today's topic. My name is Dominick Parillo. I also work with Alaina on the wealth transfer team at Savant, and I'm joining you live from our Manassas, Virginia office.
So as Dom mentioned, we have a very exciting program for y'all today. Before we dive into those new topics, though, we'll be doing that brief recap of Estate Planning 101, just to familiarize or refamiliarize y'all with the basic concepts of estate planning. Then, because a lot of what we're going to cover today has to do with trusts, we'll do a deeper dive into trust fundamentals, make sure y'all have the lingo down, know the different terms, all of that. We'll then talk about the different goals of advanced estate planning, both from a tax planning and asset protection standpoint, before we look into lifetime giving and finish out today with trust maintenance. Then we'll take those questions. So let's begin. Dom, do you want to recap Estate Planning 101?
Yeah. I'd love to. Thanks for laying it out for us, Alaina. I think we got a great program today. And as Alaina mentioned, we hosted a basic estate planning 101 presentation. We got a lot of great feedback. So the focus today is certainly going to be on trust design and some considerations there. But if you weren't able to catch or attend that webinar on basic estate planning, Savant has a YouTube channel. So you can go to our YouTube channel to access that webinar. This webinar will probably be put up there. A recording of this is going to get sent to all of the participants. But we've got a lot of great material out there on a myriad of financial planning topics, estate planning, income tax, retirement, really good stuff. So we invite everybody to check that out. And we'll start out with a sort of a basic definition, just to, again, refresh everyone's memory on what estate planning is. And when you think about estate planning, it's really the process of designing who's going to receive the assets that you own, the structure for those assets, who's going to be in charge of managing your financial affairs at death or even in the event of incapacitation. And a common goal is really to make sure that your financial assets, your stuff that you own, gets distributed in an efficient manner, reduce headaches, and try to minimize income and estate taxes along the way. And you're going to see those topics come back into play. So what are the four sort of foundational documents that everybody should have or should consider putting in place? Well, those would be power of attorney documents for property and healthcare, advanced directives or living wills that allow you to specify your end-of-life desires, whether or not you want artificial nutrition or hydration withdrawn or administered. And then, of course, the quintessential document, a last will and testament that disposes of and distributes your probate estate. And then trusts, very important. We have the term revocable living trust up on screen, but Alaina is going to go through the differences between revocable and irrevocable trusts. So these are the cornerstones of any good estate plan. And on the next slide, we wanted to bring back some terminology that you're going to hear throughout the presentation. And our plan is to send everybody who's registered today a list of these terms and the definitions. So that way you can refer back to that when you watch the recording. You check it out on YouTube because we do tend to cover a lot of information in these webinars. So it's good to have something to go back to refer and we clarify something from a terminology standpoint. So here's some key terms. Agent. Typically, when we mention agent, we're talking about the agent nominated in a person's power of attorney document, whether that be their healthcare power of attorney document or a power of attorney for property. What is a power of attorney document? Well, that is a document that allows you, the principal, to name an agent who can act on your behalf to manage your financial or healthcare decisions if you're unable to do so, usually in the event of incapacity, but not always. So agent and power of attorney go hand in hand from a terminology standpoint. And then you got executors. What is an executor? An executor is the person typically that you nominate in your last will and testament that's going to be responsible for administering your probate estate. Those would be the assets that pass in accordance with your will, typically through a court supervised process. But that executor handles your probate estate. Conversely, a trustee is the person that you nominate in usually a trust document or a will, if there's testamentary trust provisions, that's going to be responsible for administering trusts that hold money or funds for the benefit of a beneficiary. And again, we're going to get really deep into this topic today, but there's a little bit of a difference between an executor or trustee. So it's good to keep those terms separate. What is a guardian? You might hear that term a couple times. A guardian is typically a person who is appointed to manage the financial matters or custody or healthcare decisions for a minor person, usually a minor child, in the event that both parents pass away, or even for an incapacitated adult, that might have a mental or physical disability. Your last will and testament is the document that allows you to nominate guardians for your minor children or other dependent children in the event there's a need that arises, and a court does have to appoint that person. And then finally, on screen, we have the term conservator. This is the person, again, that's appointed by a court in the absence of a financial power of attorney who's charged with managing an incapacitated person's finances. All right, very good. Again, we're going to send a list of these out with definitions. And then again, just from a basic planning standpoint, I already mentioned power of attorney for property and healthcare, but that power of attorney for property document allows you to nominate an agent who can act on your behalf to make financial decisions as if they were you, writing checks, filing income tax returns, taking distributions from a retirement account, right? Anything that's not handled in your trust document with your trustee is handled by your agent under your power of attorney for property, for example. A lot of states have statutory forms. What that means is that the language that's actually contained in the document is put into the words of the law that authorizes the power of attorney for property document to be created. So a lot of times we recommend that. There's a couple of tips up here. Again, this is meant to be a recap, but important to talk to your attorney about when that agent's authority is going to be effective. Is it effective upon signing? Is it effective upon a future event, like your incapacity? Maybe there's a physician certification that needs to be done. And then I think this is a good kind of takeaway. And this goes into trustee selection as well. But it's good to nominate multiple people in the lineup of succession, just in case that prior person that you've named is unable to act. And that, again, is true for both power of attorney for property documents and healthcare documents. Of course, the healthcare document allows you to make healthcare decisions, your agent on your behalf. And then from a last will and testament standpoint, this is the document that appoints the executor and lays out what the executor's duties are when it comes to distribute your probate estate. In our last presentation, we talked about the probate process and what assets are subject to probate. But the will is different from how a trust works. And Alaina is going to talk next about some trust fundamentals.
Thanks, Dom. That was a great recap. If anyone is interested in viewing that original webinar, didn't get to see it before, like Dom said, you can find it on our YouTube channel. So now, trust fundamentals. Dom hit on this definition a little bit, but I'm going to reiterate it. What is a trust? The American Bar Association defines a trust as a fiduciary relationship where one party, called the grantor, transfers ownership of property or assets to another party, called the trustee, for the benefit of a third party, called the beneficiary. The trustee has the legal duty to manage the assets according to the grantor's instructions for the benefit of the beneficiary. So that is a mouthful. Pretty much what this means is that the trustee is holding the grantor's property for the benefit of the beneficiary. The trustee has the legal ownership over the property. It's the trustee that opens the trust bank account. The trustee applies for the EIN, which is like the trust social security number. The trustee decides which assets to invest in or which real estate to own. The trustee decides when to sell. The trustee, however, does not benefit from the property. The trustee has to make distributions to that beneficiary. So the trust agreement will say when those distributions could be. It could say something like when the beneficiary reaches age 30, they get 50% of the trust fund. When the beneficiary reaches age 35, then they get the balance of the trust. And during those interim years, the trustee can make distributions to the beneficiary for any reason. That's just an example, and the terms of the trust will stipulate when and how much of the trust can be distributed out to that beneficiary. So I have more terms for y'all, and these are the big terms that I want you to remember to take away from today that Dom and I are going to be referring to throughout our presentation. So the grantor, the person who creates the trust. There's usually only one, maybe two grantors sometimes if it's a married couple, but usually you'll only see one. The trustee, as we just discussed, and that person can be an individual or a corporate trustee. There are professional companies out there who will, for a fee and under certain terms, agree to act as trustee of a trust. And generally, the trustee is responsible for trust management. Like I said, when the assets are invested, when they're sold, things like that. They're also responsible for making distributions to the beneficiary, filing tax returns, and generally adhering to the terms of the trust. There may be one trustee, then a successor named. There may be co-trustees, meaning two or more people playing this role. The trust should also say, if there are 2+ trustees, whether those people can act independently of each other or whether they're required to act jointly. Now, you've got the beneficiary. There are two types of beneficiaries. The first is the current beneficiary. This can be one person or a group, but it's who is entitled to receive the benefit of the trust fund. For example, the trust could say, trustee, you can make distributions to any of my children for their education, including college and postgrad. My children are the current beneficiaries. There is, however, another classification of beneficiary, and that's the contingent beneficiary. The contingent beneficiary kicks in if the current beneficiary or beneficiaries die. Just because a beneficiary dies does not mean that a trust dies. And let me repeat that. Just because the beneficiary dies does not mean a trust dies. The same applies to a trustee. Just because something happens to the trustee, they can no longer act, does not mean that the trust automatically goes away. Trusts are typically structured with a series of, if this happens, then X. If that happens, then Y. So the contingent beneficiary is who kicks in if the current beneficiary is no longer with us. For example, my trust says, trustee, you can make distributions to my son for his education. If my son is no longer living, then you can make distributions to my grandchildren. My grandchildren are the contingent beneficiaries. If my son is no longer around, then my children become those current beneficiaries. This distribution to further beneficiaries, to those contingent beneficiaries, is usually either made per stirpes or per capita. Per stirpes comes from Latin and it means by branch. So let's say you have 3 children. One of them predeceases you, leaving 2 grandchildren. With a per stirpes distribution, 1/3 of your estate would go to child 1, 1/3 would go to child 2, and that last 1/3 would be split between your 2 grandchildren. Per capita, on the other hand, means by head. So in that same scenario, with a per capita distribution, child 1 would receive 1/4, child 2 would receive 1/4, and each grandchild would receive 1/4 because there's 4 heads and they all split it equally. So that's another important decision when it comes to figuring out your trusts, your wills generally. And I will say most people do choose a per stirpes distribution. So the other important topic that's going to come up a lot today is the distribution standard. So that is the what and when. What can my trustee distribute out of the trust to the beneficiary, and when can they distribute it? Trust will usually bifurcate between what the trustee can do with trust principal, which is what the grantor originally put into the trust, and income, which is what the trust has earned since that principal was contributed. Sometimes there's no difference. The trust will say, okay, trustee, you can make distributions of principal and income. Other times it'll say, trustee, keep the principal in the trust, but distribute all of the income to my beneficiary. Distributions of principal are usually limited to a distribution standard. The most common standard, which comes from the IRS, is the beneficiary's health, education, maintenance, and support, the HEMS standard. This is actually written into the tax code, so a lot of attorneys will use it. However, that standard could also be unlimited. The trust could say, trustee, you can make distributions of the income and principal to my beneficiaries for any reason using your best judgment. That's also common depending on who the trustee is. And the last term you're going to hear us use is the power of appointment. So as I mentioned, the trust will dictate what happens at a current beneficiary's death. Sometimes, though, that beneficiary will be given a power of appointment to redirect the trust funds at their death. That power of appointment could be narrow, say to only descendants of mine, or it could be broad, anyone that the beneficiary desires. The beneficiary usually has to exercise this power of appointment by notifying the trustee, either in writing during their lifetime or in their own estate planning documents. This can be a really big power, so make sure if you include it in your own trust and estate plan that you understand the ramifications. So speaking of your own trusts, big theme again of today, choosing the beneficiary and the trustee are usually going to be the biggest decisions that you'll have to make for your trust. So make sure you spend some time thinking about those people before you sign any documents or make any transfers. Sometimes you, as the grantor of the trust, can change these people. That's possible if the trust is revocable. Sometimes, though, you can't change these people or any of the trust terms if the trust is irrevocable. So a revocable trust is a tool that we see in many clients' estate plans because it's a tool most often used to transfer assets at death and by avoiding probate. We talked about revocable trusts pretty extensively in Estate Planning 101. So for greater detail, I'm going to refer you back to that webinar. But as a general recap, the grantor can amend a revocable trust at any point that they are living and have their testamentary capacity, which pretty much means that they understand what they're signing. These trusts typically do not provide any asset protection or provide any tax planning benefits to the grantor while the grantor is living. However, at the grantor's death, they typically do become irrevocable. And at that point, that's when tax and asset protection goals can kick in. One thing to note, The living part of a revocable living trust means that it was created while the grantor was alive. A living trust can be revocable or irrevocable. A testamentary trust, on the other hand, that means a trust that was created under a last will and testament. And it's usually only irrevocable because the grantor created it under their will. And for their will to come into effect, the grantor has to be dead. Once you're dead, you can't really change your trust. That's how that works. Irrevocable trusts, on the other hand, cannot be changed by the grantor. I'm going to repeat that again. Irrevocable trusts cannot be changed by the grantor. They are irrevocable, unamendable, unchangeable. Because the grantor cannot change them, they do offer significant asset protection and tax planning opportunities. Why? Because when assets are put into an irrevocable trust that the grantor cannot change, and the grantor puts those assets into that trust, they are transferring ownership to the trustee. They have made a gift. If I give you $100, that's yours. You can spend it however you want. I don't have control over that $100 anymore. If I give $100 to the trustee of an irrevocable trust with trust terms that I cannot change, I no longer have any control over how that trustee spends the $100, so long as it complies with the trust terms. Transfers to irrevocable trusts are subject to gift tax laws. Pretty much any time you transfer assets to someone other than your spouse, and that includes to trusts, you are subject to gift tax laws. There is an exemption amount that Dom is going to go over in a few minutes, but generally, if you create an irrevocable trust during your lifetime and you transfer assets into that trust that are valued at more than $19,000 per beneficiary of the trust, you have to file a 709 gift tax return, notifying the IRS that you've used some of your lifetime exemption amount. I'm going to talk about this a little bit more when we talk about lifetime gifting, but do know that these gift tax laws typically do not apply to transfers to revocable trusts because you, as the grantor, still maintain control over how those assets are managed. So if you're thinking about including trusts in your estate plan, and Dom is going to tell you one reason why you would want to do that in a minute, it's going to be a balancing act. When you're thinking about your goals and the types of trusts that are available to you, you'll need to consider how much control you want to retain over those trust assets. You'll also, again, need to consider who you're naming as trustee, because remember, this may not be an appointment that you can change depending on the type of trust that you have. Also, especially with irrevocable trusts, you have to weigh the income tax advantages and disadvantages of using this tool. With some irrevocable trusts, the grantor will continue to pay the income taxes on the assets in the trust. With other irrevocable trusts, the trust itself will pay income taxes. And sometimes the beneficiary will pay the income taxes if the income is distributed out to that beneficiary. Also, typically with gifts to anyone, whether they're made in trust or not, that asset that's gifted retains the grantor's basis and does not get a step up in basis at the grantor's death, meaning that when the beneficiary goes to sell that asset, they will pay income taxes on the growth between when the grantor originally purchased the asset and the time of the sale. This can be a huge income tax consideration for both the grantor and the beneficiary in this type of planning. So a lot of balancing has to be considered. Now, this all seems like a lot of work. Dom, can you tell us some reasons why we would still consider using a trust?
Absolutely. And as you mentioned earlier, Alaina, when you were going through some of the terminology for trusts. You mentioned that there's distribution standards that the grantor puts in the trust document that will then tell and instruct the trustee how they can distribute money. And we thought that we would start with the tax planning aspect of trusts. And really, we're talking about estate taxes because the language used in your trust documents or trusts that you might be a beneficiary of is really a child of the tax code and the federal estate tax system that we have. So it's a good springing or launching point. And I think to frame things up, it's good to have a sort of a historical view of what the estate tax exemptions are and have been and where we might be headed. Because again, this could influence the potential design of your trust plan if one of your goals is estate tax planning. So here's a chart of the estate tax exemptions from 2011 through 2030. There's some projections there. But the estate tax exemption is the amount of money that you can leave to your loved ones or your beneficiaries without incurring federal estate tax. And right now in 2025, each person has a $13.99 million federal estate tax exemption, which means that if you're a married couple, you can pass just under $28 million in asset value to your family and other loved ones without any federal estate tax. And as Alaina mentioned, and she'll surely mention again when she talks about lifetime giving, if you do make a gift beyond the $19,000 annual gift tax exclusion amount, it just uses up some of your lifetime exemption, which then reduces what's available at your death. Now, one interesting thing to note is that up until 1997, the federal estate tax exemption was $600,000 per person, much lower threshold than the $13.99 million number that we have today. And because of that, a lot of the language used in trusts was really focused on credit shelter trust planning to basically keep assets outside of the taxable estate of the spouse or future beneficiaries because of the exemption being so low. Well, with the increase in exemptions, the 13.99 million under the Tax Cuts and Jobs Act, a lot of the focus for ordinary people, even people with modest wealth, has been focused on trust distribution design and asset protection, which is what Alaina is going to speak about in the next segment. But it's good to keep in mind, these estate tax planning vehicles and how they could impact you. So everybody typically focuses on federal estate tax. That system gets a lot of airtime. Before we jump to the next slide on state estate taxes, I want to note that at the federal level, there's a concept called portability, which means that if you pass away and you leave all your assets to your spouse can use your exemption at their death and add it to their own number. That feature is not available in every state. So on the next slide, you'll get a glimpse of which states have estate tax or inheritance tax. And if you find yourself living in one of these states, even if you don't have a federal estate tax problem to worry about, you need to be very mindful of the state estate tax threshold, which would require some additional work and thought with your attorney on how to minimize overall estate tax for your loved ones, if that's one of your objectives and goals. So there's 12 states and the District of Columbia that have a state-based estate tax. I believe the only two states that have the portability feature at the state level are Maryland and Hawaii. I hope I'm getting that right. So again, you need to have a little bit extra potential planning provisions in your documents, depending on what state you live in. So for example, Illinois, which is where many of our Savant clients reside, has a $4 million per person estate tax exemption that's not indexed to inflation, and there's no portability. One thing I forgot to mention on the previous slide is at the end of this year, 2025, the federal estate tax exemption is set to sunset, which means the Tax Cuts and Jobs Act is going to expire without congressional action. And we expect a $7 to $7.5 million per person federal estate tax exemption. But again, this is something that is being worked on right now by Congress. There's a chance that the estate tax exemptions might get extended for another 10 years in a reconciliation bill. So we're always being mindful of what these exemptions are. And it's good to review your balance sheet and net worth assets from time to time, just to see if there's any proactive planning that you can do. Okay, let's take a look at a hypothetical situation. And we're going to focus on an Illinois resident in this example, because there's both federal and state estate tax issues at play. And I think it's a nice example to go through. So this is a business owner client, hypothetical client. They've got some liquid assets, savings outside of their business, and after-tax accounts, brokerage account, bank account. They've got their business. They've got some real estate, some life insurance, and some retirement accounts, IRA, 401k type assets. Their total estate value is $20.97 million. Now, not all of us are going to be as lucky as this particular example to accumulate $20.97 million. But again, don't think that trusts aren't for you, because as Alaina is going to cover in the next section, there's a lot of other benefits that trusts can provide beyond your death to your loved ones, whether that be a spouse, a child, grandchildren, other people that you care about. And given the current estate tax exemptions of $13.99 million per person, this client, and we'll assume that it's a married couple, they have no federal estate tax if they both died today in 2025, because again, there's a $28 million roughly combined exemption. But because they're Illinois residents with a $4 million exemption per person, if they don't do any advanced planning, they might have a $2.1 million state estate tax liability if they both passed away in 2025. If there is a change in the federal estate tax exemptions, like I mentioned before, at the end of this year or in the future, in this case, we were assuming a $7 million federal estate tax exemption if there is a sunset. You'll see that if those clients die with $20.97 million in assets, the state estate tax number is the same, because there's just $4 million per person exemption in Illinois in our example. But now there's a $1.8 million federal estate tax liability for a total of $3.8 million. And there's a note there, and you'll see this in the next couple of slides. If this couple did some proactive planning to shelter assets for purposes of Illinois estate tax, because there's no portability feature, they could save $330,000 in state estate tax. All right. And I don't think anyone will argue that tax savings by updating their estate plan and planning for this probably justifies that fee that they would pay the attorney to do the estate planning design, right? Pretty compelling to pay attention to this. There's real tax.
It's probably a good bang for your buck.
Probably a good bang for your buck, right? When you look at numbers like that. Mm-hmm. How do assets flow in a trust, again, from a estate tax planning standpoint? Well, a lot of times people have very basic trusts, or maybe this is similar to what their will would say, where at the first death, everything just passes to their surviving spouse outright, free of trust. What does that mean? That surviving spouse just takes that inheritance and they just add it to their own assets in their name. Okay, it's like the typical I love you plan. Here you go, everything's yours. But then if that spouse predeceases, right, or dealing with the second death, then the estate is just distributed to, in this example, the client's children, again, per stirpes. And Alaina defined that term earlier, right? A typical, really basic estate plan setup. This is great for many, many people. Now, what's the disadvantage of this approach? Distributing the assets outright and free of trust to the surviving spouse. Well, now all of those assets are included in the spouse's estate for both federal and state of Illinois estate tax purposes. And again, there's no portability of that state of Illinois estate tax exemption, right? So everything's just included in the spouse's estate. They can do whatever they want. They have a general power of appointment over those assets, okay? So how do estate planning practitioners solve that problem potentially? On the next slide, you'll see a different structure where perhaps the spouse's own assets that they own are given to them outright. This is a joint trust example. But the deceased spouse's half of the assets, instead of being given to that surviving spouse outright, are held first in a family trust or credit shelter trust up to that state of Illinois estate tax exemption, $4 million. And then everything over that might go into a marital trust that's exempt from federal estate tax at the spouse's death. And what makes those trusts, these family and marital trusts, potentially exempt from estate tax? It gets to that HEMS standard that Alaina outlined earlier. Right, the tax code says that the assets that are in the spouse's name or assets in which they have a general power of appointment over are included in his or her estate for estate tax purposes. So there's a set of magic words, if you will, typically health, education, maintenance, and support, that's considered an ascertainable standard. And if the spouse is the beneficiary of that trust and that standard applies, generally those assets aren't going to be included in the estate of the surviving spouse for estate tax purposes. And those trusts typically allow the spouse reasonable access for those purposes. It's not unlimited, right? It's an ascertainable standard. But the trustee is going to take those distribution standards in mind. And then the assets that fund that trust at the first death, those would grow estate tax free, right? The spouse still has access to them. At the spouse's death, those assets can still pass to the children, right? Alaina's going to talk about some asset protection ideas for children and descendants in a little bit. But that's the general idea, right? You can create a trust for that spouse's benefit at the first death that's designed to shelter and keep those assets out of the estate of the surviving spouse. All right. Let's see if there's anything else that I wanted to mention here, but I think we got the basics. It's called credit shelter planning. Again, speak with your attorney about what makes sense for you. Okay, Alaina, we talked about estate tax. Let's talk about asset protection, because again, not everybody has an estate tax problem.
Ooh, taxes. And while I do wish all of our clients an estate tax problem, it can certainly add a lot of complication to an estate plan, as Dom just demonstrated. So let's switch gears and talk about asset protection. So I'm going to be focused solely on domestic asset protection strategies. This discussion doesn't include anything offshore, no Cayman Islands, no New Caledonia, nothing like that. These are basic strategies that most anyone can take advantage of with a pretty low degree of risk. So when looking for asset protection, the first thing you're going to need to ask yourself and your advisors is, who are you looking to protect your assets from? The most common creditor that I hear about from clients is the IRS. And so Dom just gave you a good recap about tax planning, so I'm going to skip over that one. The next creditor that clients worry about is an ex-spouse. So that's whether current or future. Remember, when we're looking at asset protection, you're not just thinking about your own creditors, your own marriage, but also your descendants as well. And then there are also two general categories of creditors that we think about: the known and the unknown. Known creditors you can keep at bay today with irrevocable trust, as well as at your death for your children, by creating these testamentary trusts I'm going to talk about. And then unknown creditors are just that. They're unknown. No one knows what the future holds. Anyone can be sued for anything at any time. How well prepared you are will determine how quickly a lawsuit can be thrown out. So if you're not doing tax planning with irrevocable trusts, or you're not doing those spousal trusts that Dom talked about, because you're not facing substantial federal or state estate tax exposure, you may still want to include testamentary irrevocable trusts for your descendants in your estate plan. So I'm going to focus on those big orange circles on your screen, the trust for your kids. These testamentary trusts, which are either created under your last will and testament or under your revocable living trust, are created at your death. Typically, each of your children would have their own trust, but you may also see something called a pot trust. Your attorney might recommend that, where all of your kids are beneficiaries of one big trust. You may have in each of these trusts something that I call distribution trusts. These are usually for younger children who have yet to reach the legal age of adulthood, and your goal is to get them to an age where they can handle a large sum of money. Distribution trusts are usually structured with the principal being distributed out of the trust to the child beneficiary in certain percentages at certain ages. Let's say 25% at age 25, 50% at age 30, and the balance at age 35. At age 35, the trust terminates. During those interim years, the trustee, who's usually not the child, can make distributions in the beneficiary's best interest. This is not the ideal trust structure for asset protection, because once the trust fund is distributed out of the safety of the trust net, once it's handed over to the beneficiary, there's no more asset protection, none. It becomes a part of their taxable estate for estate tax purposes. It may become open to their spouse in the event of a divorce if it's commingled with marital property, and it may definitely be open to all of those creditors. So if you're concerned about asset protection and you want to give your kids sort of a better vehicle for their inheritance, one of the things that you could look into would be a lifetime descendants trust. And that's what I have modeled here today. These descendants trusts are going to go for your child's lifetime, and then they'll go to your grandkids and your great-grandkids for so long as state law allows. They cascade from one generation to the next. So in this example, we would have 50% going to child's one trust and 50% going to child two's trust. Their trusts have nothing to do with each other, so you don't need to worry about fighting or conflicting ideas about management, nothing like that. In this example, the trustee, who may be that child, depending on the child's age and financial maturity, can make distributions of the principal and income to the child for their health, education, maintenance, and support, that HEMS standard. This trust may protect the child's inheritance from divorce, from creditors, from future estate taxes. Those walls of the trust in this example would be protecting about $3.5 million. And with good drafting of your estate planning documents, you can provide your child with substantial flexibility to manage this trust, benefit themselves and their families for many generations to come. This is how we normally see generational wealth preserved, created. Because
that's great, Alaina. Can I jump in real quick?
Yeah, of course.
And again, I think this is really where most people are focused. This structure, right, for their spouse after the first death, and for future generations. And I think you brought up some very good examples. A lot of clients we work with are really concerned about a potential of divorce in the future, or maybe they have very young descendants, right, that aren't able to manage money. So I know you said these things earlier, but I wanted to highlight that again, that if you said, hey, I don't have an estate tax problem, I'm kind of tuned out. Well, don't tune out on these details, because that inheritance structure that you create, very important for how this wealth is stewarded for your loved ones.
That's exactly right, Dom. And it is just really important to remember that this is for anyone, because these trusts are created under your core estate planning documents that you should have anyway. So definitely consider talking to your attorney about it. And once you've decided that you do want to create these trusts for your descendants, you have a lot of control over how they're structured. You have to think about how much flexibility do you want to give your child versus how much control should the trustee retain. You know your children best at this stage of their lives, whatever it is. And again, the good thing about these trusts is they're typically created under a will or a revocable trust, meaning you can change them at any point. So you also can decide to give them that power of appointment that I discussed earlier. You write down in your will that the trust passes to your grandchildren at a child's death, but they have that power of appointment that they can exercise in their own estate planning documents that allows them to deviate from that structure. You can make this power as broad or as narrow as you'd like. Choose the groups of people to whom your child can exercise it for, who they can leave their trust fund to. This provides additional flexibility to that child because, if they're going to be around for another 50 years, who knows what the tax law is like? Who knows what their family situation is like? It just gives them additional flexibility. And then you remember, I just said that your child may be trustee of their own trust. That is possible with that HEMS standard. Is very powerful. So long as they're limited to that standard, a child generally can be trustee of their own trust. An independent trustee, meaning someone who has nothing to gain from the trust, isn't a beneficiary, they can generally be given an even broader distribution standard. They can make distributions for any reason. Why? Because they don't have anything to gain. So presumably they're making a smart decision because the trustee is a fiduciary. They are held to a higher standard of care in managing trust assets. Again, which is why picking that trustee is a very important decision. I will say a lot of times what trust agreements will include is the beneficiary's ability to appoint a future trustee. So at that beneficiary's death, they can name the future trustee for their children. They don't have to be structured the same way that you did. So that's a really powerful power. So all of this trust talk may have you thinking about gifting and whether you want to gift with warm or cold hands, meaning during life or at death. A lot of people prefer to see their gifts distributed to loved ones and watch them enjoy themselves while you're still around. So remember that gifts at any point are subject to gift tax laws. They're subject to that exemption that Dom talked about a little bit ago, and that you can always make lifetime gifts outright. Go ahead, write someone a check for $5,000, pay for your grandkids' school, make that outright gift. But what if you want your lifetime gift to include the asset protection of a trust? Or if you want to use trust for tax planning? This is a whole topic in and of itself. So I'm just going to do a quick overview of the big ideas behind lifetime gifting to trust. So as we've discussed, only transfers to irrevocable trusts include tax planning opportunities and asset protection. With a revocable trust, because you can change it at any point, you don't have those same tax opportunities or the asset protection. So for this talk, I'm only going to be talking about transfers to irrevocable trusts. Once you've decided that you want to establish an irrevocable trust, you'll need to decide who you want to have as that trust beneficiary. So while you can create a trust for anyone, most clients create trusts for the benefit of their spouse, their kids, themselves, or charity. A trust set up by you or your spouse is usually called a spousal lifetime access trust or a SLAT. The benefits of a SLAT are that you can use your exemption and freeze the value of any gift you make to the trust for estate tax planning purposes. But your household, via your spouse, who could also be the trustee, can still access the assets and the income from those assets after you move them into the trust. The downside of a SLAT is that you are limited to your own personal exemption amount for gifting purposes, or in other words, you can't split gifts with your spouse. So that means you can only gift up to $13.99 million, which I think for a lot of people is a crazy idea to begin with. But if you're doing it for estate tax planning purposes, there's a lot of benefits to doing it this way. So you may also be thinking, can I put these assets in trust for my own benefit? If I have an irrevocable trust that I am the beneficiary of, can I get protection from my own creditors as well as do some estate tax planning? Well, the answer is yes, but with some buts. So trusts you create for yourself are called self-settled trusts, and they're only permissible in some states. All of trust law is state-based, even though a lot of federal law does come into play because of the tax ramifications of trusts. So some states have decided to be trust-friendly, and you'll see some of those states listed here on the screen. However, even if you or your assets are not physically located in those states, you may still be able to set up a trust in that jurisdiction as long as you have a trustee based in that state. That's a lot of times where those corporate trustees come in. Sometimes they'll offer that service. There are typically substantially higher costs to set up these sorts of trusts, but a lot of times you may be able to make that up with that state's lack of income tax. So again, a lot of this trust conversation is all about balancing. And the last, trusts for charity are just that. A lot of times charitable trusts that are created during lifetime, they're used more for income tax planning, but they can have estate tax benefits as well. The last decision that you'll need to make when setting up irrevocable trusts is what assets you're going to be placing into them. What assets are you giving away? So for estate tax planning purposes, the best gifting assets are hard to value. So small businesses, real estate, artwork, things that don't just come with a price tag, that aren't traded on the open market every day. Also, assets with a higher basis are usually best because the asset does not get a step up in basis for income tax planning. So I'm going to summarize the steps of gifting in a minute, but you do need to provide adequate disclosure of the value of the gifted asset to the IRS. So what would a third party pay for it? For most assets, you'll need to provide that third party valuation. So a realtor's opinion of the value of land or a professional business appraisal of a small company. Getting these valuations and opinions can get expensive. So again, you'll need to be ready to take on this project financially. However, the creditor and estate tax protection can be invaluable to both you and your family. Some gifts are much easier. You may have heard of a life insurance trust or an ILIT. That was pretty common when the estate tax exemption was lower. It's when the death benefit of a life insurance policy is included in your taxable estate when you die. A lot of people don't realize this. So to avoid that happening, you can put the life insurance policy into a life insurance trust. You change the owner and beneficiary of the policy to be the life insurance trust. With that easy transaction, you can avoid adding possibly millions of dollars to your taxable estate. Liquid assets, again, those can be gifted to a trust, but they may not be as ideal because they have a calculatable value as of the day of the gift. Cash is worth what it's worth, and anyone can look up the value of a stock to see how much it was in the market on the day that you gifted. So while you can put liquid assets into a trust, it's always a good idea to look at what other options you have available to you first. And one thing to note, not all assets can be put into trust. Retirement accounts such as IRAs and 401ks can never be gifted away while you are living without losing their tax status. So do keep that in mind. Other assets such as company stock, deferred comp plan benefits or key man benefits, those may have restrictions that prevent them from being transferred into a trust also. So this slide here shows you what two spousal gift trusts look like. There are different beneficiaries and different trust terms. What I want you guys to see was that when you're creating the trust, so long as it's not unethical, the world is your oyster. You can pick any terms, beneficiaries, trustees, ages of distribution, anything like that. And so if you do think that it would be worthwhile to your estate plan to do some of this lifetime gifting for estate tax planning purposes, there are various steps of gifting that you need to be aware of. You have to create that irrevocable trust, prepare the assets for transfer, actually transfer the assets, sign the deeds, move the accounts. That's important because then you get that date for the value. For the value, you need to provide valuations. You need to have that third party chime in and say, hey, this is actually what it's worth, not just your personal opinion. And then lastly, all of that information needs to be compiled in a 709 gift tax return. That's due on April 15th, tax day of the year after the gift is made, along with your personal income tax return. It can be extended to October if you extend your personal income tax return as well. And the benefit of doing this is that a timely filed 709 starts a 3-year statute of limitations for the IRS to contest the values of the gifts that you've made. So that's very important. So last, to show you this, our sample family again, you'll see those yellow trusts to the side. Those trusts are irrevocable, protected from creditors, and holding various assets. They can be a very powerful tool in your estate plan and should be if you're in that taxable estate range, either now or after the sunset at the end of this year, if that happens. Also, your estate plan has become very complex. And, that's why it's important to have a good team of advisors to help walk you through these processes and to help you maintain this structure. Dom, can you tell us a little bit about trust maintenance?
Absolutely. So just a couple of points about revocable living trusts, because I think this trust concept can be somewhat intimidating to a lot of people and even foreign to them. But like Alaina mentioned earlier, when you create a trust and it's revocable, you can change the trust terms. So that doesn't really complicate the grantor or the person who created the trust's life at all, because that document is done, it's executed, you work with your attorney to create the terms, all the planning provisions you want, and then that trust is really you for all intents and purposes when it comes to annual income tax filing. So you're opening up the account under your Social Security number. It doesn't really change anything you're doing in your day-to-day life. Now, there is a step after you do the trust documents to actually fund those trusts, which might involve some titling changes. And we covered that in a great amount of detail in our Estate Planning 101 presentation that we would refer you back to. But what about irrevocable trusts, right? The trust that you create during your lifetime that's irrevocable under its terms, or the trust that becomes irrevocable after you're no longer with us and you pass away. Those trusts may and often do have annual income tax filing requirements because the trust now becomes its own tax-paying entity. And there's an income tax return called a 1041. That's the number of the tax return where that income is reported and the trust pays tax on any undistributed income. Now, trust tax brackets are more narrow than individuals. So again, that will get into the calculus of your overall plan design, and you have to weigh some of the costs and benefits for creating these trusts for your loved ones. The fiduciary, or that trustee that's going to be managing those trust assets for the beneficiary, is going to have an ongoing obligation to make distributions under the trust terms for that beneficiary, looking into their financial condition and situation, make sure that distributions are appropriate and that the beneficiary's needs are going to be met. And then those trustees are usually always, under most state law, required to provide information to the beneficiaries at least annually. A listing of the trust assets, any liabilities associated with the trust, and then a summary of all the receipts and disbursements, right? What was distributed to the beneficiary, what was paid on behalf of the beneficiary, and then what were the expenses of administering the trust, the other things that the trust money was spent on that wasn't for the beneficiary's benefit. So a couple of things that need to be done, depending on the trust structure and the type of trust that we're working on. Okay, and we mentioned on the next slide the annual tax filings, and Alaina's mentioned the gift tax returns, again, Form 709, when you do make gifts above that annual exclusion amount of $19,000 in 2025. And with that, and then I think we can take a few questions as well.
Okay, so let's see some of the questions that came through. Dom, I think this is a good one for you. My husband just passed away. Do I need to file an estate tax return?
This is a very good question. We spoke earlier about the federal estate tax system and how the exemptions are very high right now. So whether or not you need to file an estate tax return is going to be dependent on what your total wealth picture looks like when you take into consideration what you're receiving from your spouse and what you have as the survivor. But I think generally, even if you're not in danger of having an estate tax problem now, at least federally, it might be a good idea to go ahead and file that estate tax return, which is a Form 706, for that portability feature that I spoke about earlier. If you want to use the benefit of the first spouse to die's federal exemption at your death, you have to do an estate tax filing return just to tell the IRS where the assets transferred, was a credit shelter trust funded, what did that spouse own, and then you can pick up that exemption on your own estate at your passing. And then also, if you live in one of those states that has a lower estate tax exemption, you may find yourself in a position where you do have some state estate tax obligations to worry about or potentially address. So talk to your attorney, talk to your accountant, talk to your advisors to determine whether it makes sense for you to file one.
Great, thanks, Dom. One of the other questions I'm seeing, if I gift assets away, can I get them back ever? So going back to my example of, hey, Dom, here's $100. I give it to you. Can I get it back from you? No. You may choose to give me $100 back, but that again is a taxable gift. With a trust, they can't gift assets because they're not a person. And so once those funds go into trust, unless that grantor is the beneficiary, which is rare, those assets cannot come back to the grantor. There are different ways to get around that. For example, the trust could sell the asset back to the grantor. They could do a swap, meaning the grantor could put in $100 worth of stock and take out $100 back. That's possible in some sorts of trusts, but generally, no, you can't just take money back from an irrevocable trust. Another question. I am the beneficiary of a trust. Can I change the trust? Tom, do you want to cover that one?
Sure. And Alaina, the first step in any of these questions is to read the trust document and determine what the terms are. Because as Alaina mentioned earlier, you may, as a beneficiary, have been given a power of appointment over your trust assets at your passing or even during a lifetime. So that's something to evaluate. Do you have that power of appointment? And what's the scope of that power of appointment? And when does it become effective? Can I do it now or at my death? And then in some cases, some states do allow irrevocable trusts to be changed via non-judicial settlement agreements, via trust decantings. But that's an advanced concept that you'll have to certainly speak with your attorney about to determine if it can apply to you in your situation. Alaina, do you have any thoughts on posthumous trust modification? I know this is something that's come up recently.
I think maybe this could be the topic of our estate planning 301 webinar.
Perhaps.
Maybe y'all will just have to wait until next time to see if we dig deeper into changing irrevocable trusts.
Keep everyone in suspense.
Exactly. So we'll leave y'all on a cliffhanger today. Thank you so much for joining us. I hope it was educational. And please, again, feel free to reach out with any questions or schedule that 15-minute call.
Thank you,
Bye.
everyone. Bye.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.